A white professor has filed a discrimination lawsuit against Texas A&M, arguing that affirmative action policies prevent him from getting a professorial job with tenure because he is white. So arguing that there has been racism as applies to him, discrimination on the basis of his skin color. All right, let's go ahead and read this. In a class action lawsuit filed September the 10th, the University of Texas Austin associate finance professor Richard Lowery argues that Texas A&M's hiring policies favoring underrepresented minority groups exclude whites and Asians. So he currently has a job at the University of Texas in Austin. He would like to apply for a position at Texas A&M, but he has some problems, he says, because of race. His lawsuit has asked a federal judge to declare the university's race and sex-based preferences to be patently illegal under the Civil Rights Act. The complaint cites Title VI and Title IX of 1964, which prohibits universities from discriminating on the basis of race in the case of Title VI, or in the case of gender in the case of Title IX. So this is a lawsuit that's interesting, and there is currently before the U.S. Supreme Court a case dealing with this issue as it relates to student admissions. Students for Fair Admissions versus Harvard is being heard this term by the U.S. Supreme Court. It's being heard this fall, I believe. I forget exactly when. It's either like October, November. It's earlier in the session, so it's coming up pretty soon. And dealing with race-based preferences or race-based advantages by public universities, which has been permitted since a case, ironically perhaps, coming out of the University of Texas Austin. The current case law that allows for colleges to use race in some sort of preferential race was a case called University of Texas versus Fisher, which is the current case law. But the Supreme Court is rehearing, basically, University of Texas versus Fisher, and all indications are, of course, the U.S. Supreme Court is going to reverse University of Texas versus Fisher and say that race-based preferences, race-based advantages, race-based discrimination is unconstitutional because it, because of, for example, Title VI and because of the Constitution. So this professor is adding to that chorus, and one would imagine his issues would turn on the Supreme Court's decision in Fisher, or the Fisher successor of Students for Fair Admission, and we'll see how that all pans out. Both the University of Texas in Austin and Texas A&M are public research universities. With more than 70,000 students, and that is a lot, Texas A&M has one of the largest student bodies of any university in the nation, the largest student body. So, yeah, apparently Texas A&M, 70,000. I mean, damn, I went to Clemson, which has a total student body of, I think, 23,000. So that's like, it's 3 times as many. That's a lot. The Vice Chancellor of Marketing for Texas A&M said they will review the lawsuit and take appropriate action as needed. And then they have this little quirk in there, this little quip, by saying it's an unusual job application. When Mr. Lowery says in the lawsuit he's able and ready to apply for a faculty appointment. So they're giving a little dig there. Thus, that brings us to the end of the discussion of the story of the white professor who sued for racism. He argues that because Texas A&M has preferences for people of particular races, that necessarily is a non-preference for people not of those races. To benefit someone necessarily is to prejudice someone else. If you're not giving everything evenly, if you're giving someone a benefit, you necessarily have to do it at the expense of everyone else. Otherwise, it's not a benefit. And he argues, well, that's discrimination on the basis of race. They are, by their own terms, giving preferences to people who are particular races, particular minorities. And that's illegal. And the case law on this, as I've mentioned, at least in admissions, is governed by University of Texas Austin versus Fisher, but it probably will be governed in the future by Students for Fair Admission versus Harvard, which looks to overturn race-based preferences of any kind. So we'll see how that all pans out. Should be interesting, and that for the moment brings us to the end of discussion of this case.